Hey guys, this is Hearn-Rushton with the Rushton Law Firm here in Nashville, Tennessee. I'm an attorney and partner with the Rushton Law Firm, and we handle a lot of divorce and domestic actions as well as other civil actions in the Nashville area and surrounding counties. Today I have a topic to talk to you about related to divorce, which is how is alimony awarded in a divorce action? This is a topic that comes up quite often, for good reason, obviously. Most people want to know, number one, am I going to be paying my spouse alimony post-divorce? And number two, am I qualified to or will I possibly receive alimony? So those two situations come up in a lot of divorces. Not every divorce, but in a lot of divorces. Now, I will tell you that alimony is something that is primarily based upon two things. Number one is an ability of a party to pay alimony, and then number two is a need of the other party to receive alimony. Generally speaking, the courts in Tennessee relate this as a party being disadvantaged, in other words, needing alimony, or a party being advantaged, the advantaged spouse that has the ability to pay alimony. And so, how does that occur, and how do we find out if we're the disadvantaged party versus the advantaged party? Well, number one, usually the advantaged party has an economic advantage over the other party in that they either have assets of some sort that they can rely upon to pay the monthly bills and to cover the needs of the family, the spouse, themselves, or otherwise. And the disadvantaged party is a person that generally doesn't have enough money to make ends meet each month, especially post-divorce. And so our legislature has set up, statutes that cover this. 36.5.121 is the statute that controls alimony in Tennessee. So we have four types of alimony, and certainly you're going to want to know a little bit about those. And we'll just touch on them briefly today, and possibly go back and then do some more videos to cover in depth each one of the types of alimony in Tennessee and what it means and how they're awarded. Basically, we have alimony and Futuro, which is the one that a lot of people are actually familiar with, and that is a alimony into the future, so to speak, that is modifiable, but it's an alimony where you have a spouse that is, say, disadvantaged because they have a disability, or they have an issue where they're probably never going to be able to actually bring themselves up to a point where they're in a position to take care of themselves into the future. The second kind of alimony is an alimony in Solido. That's where you have a one-time payment. That payment is to kind of equalize the equities, so to speak, between the parties, and that's where generally one spouse has a relatively large amount of money, let's say in the bank or in stocks or otherwise, that they can transfer to the other party in a single payment. So in Solido is a one-time payment generally. Now it can be set up in installment payments month to month, but generally we would expect that to be a one-time payment. We also have what's called transitional alimony. Transitional usually comes in when we have shorter term marriages and we're in a situation where someone is going from the married life to divorce, and they're trying to transition from being married into the divorce single life again. And so an advantaged party has the ability to pay that transitional alimony to the other party that's in need of, maybe they don't need a full amount of alimony to cover all their bills every month, but maybe they need, say, $2,000 a month or something just to get by until they transition, until they get themselves into a position where they can fully cover their bills and move forward without the help of the other spouse. We would expect, like I said, to see that to be a shorter term alimony, not necessarily extremely long. But transitional, also one of the important things is, unless it's stated in your divorce decree or in your marital dissolution agreement, it's non-modifiable. So if you're on the paying end of that, you need to be very cautious about entering an agreement to pay transitional alimony. If there's any chance you're going to lose your job or lose your income and not be able to do that in the future, then you could be in some serious trouble with the court if you are in a position at some point in time later where you can't pay that transitional alimony to your former spouse. So just be cautious about that one. Then we also have rehabilitative alimony. Rehabilitative alimony is modifiable into the future for either side, but rehabilitative is also a shorter term alimony, and it is generally paid where you have a spouse that, let's say, one spouse is advantaged and they have the funds and ability to pay the other spouse, but the other spouse is economically disadvantaged because, let's say, they need to finish college or they need to finish a trade or some type of training, and they can't really take care of themselves fully post-divorce until that transition or that rehabilitation is actually taken care of. And so in that instance, we would expect it to be a shorter term, let's say 4 years, for a party to finish a college degree, or finish a trade program so that they can then pay all of their bills each and every month into the future. So, it's not set at, let's say, 4 years, but it could be a shorter term, like 4 years, 2 years, 3 years. It's generally, we see that as a shorter term. It's modifiable, like I said. Generally, the modification comes in where you have, let's say, an advantage party that's doing really well. They're making plenty of money. They're paying their rehabilitative alimony to the other spouse, and the other spouse is in a trade program. Let's say they get 2 years in, and it looks like they're going to need a third year to finish before they can start earning money. That might be a situation where the court has retained jurisdiction, and that needy party could go back to the court and say, hey, I've done my best, I've really tried hard, but I still need another year of this alimony, and she or he has the ability to pay it, and I'm going to be in trouble here if I don't, get a little bit more money for another year. And the court might take that into consideration as a material change of circumstance, whereby that need is something that should be awarded and extended for a lengthy period of time or a longer period of time. Okay, now, the other question that we get into here is, am I going to have to pay alimony? Well, as I said earlier, the advantage spouse is the one that's probably on the hook for paying some alimony to the other party. And that comes into that need and ability analysis. And so that gets broken down a couple of different ways. Number one, certainly you have to have the ability. If you don't have the ability, at the end of the month, if your legitimate monthly bills is either taking up all of the money that you're making or exceeding that amount of money, then as long as they're legitimate bills, there's a good chance that the court's probably not going to order you to pay alimony to the other party, even if they are in need, because, as they say, you can't get blood out of a turnip, right? But that does not mean when you start a divorce, go out and quit your job and, stop earning money because, that might keep you out of alimony. Well, actually, that's probably not going to help you at all. It's actually going to be a problem for you if you try doing that. And many a person has tried it, and many a person has failed at that. So that's not a good strategy. You have to maintain the status quo to the best of your ability whenever a divorce action is filed, and you have to keep on, working and doing the things you've been doing before and paying the bills that you've been paying prior to the divorce action being filed. Likewise, the need of the other party comes in where you have a party that, for instance, they're, say, working part-time. Let's say they make $2,000 a month, but they realize they're living in Nashville. It's going to cost them $4,500 a month to run an apartment and pay their bills and pay their utilities and so on, put gas in their car, go back and forth and pay a car note. But they just can't do it right now. They only make $2,000. They're in whatever position they're in because economically they just can't make it. But the other party has disposable income of, let's say, $3,000, $4,000 extra per month. Then that's a situation where the needy party can petition the court and ask for alimony, one of the types of alimony that I just mentioned earlier. And like I said, that could be in Futuro, that could be transitional, could be rehabilitative, and it will depend on the 12 factors that we discussed earlier in Section 36.5.121. And as I said, those 12 factors break down certain things, and I'll just go through a couple of those. Length of marriage is important. If it's a short-term marriage and your disadvantaged party isn't disabled or doesn't have a long-term disability, I wouldn't expect to see in Futuro type of alimony to be awarded. We also look at the earning capacity of the parties. That comes in where I was talking about education, where your disadvantaged party doesn't have the earning capacity and they need to do something to improve their position where they can earn more money. So that's another factor that's considered. Separate assets can also be considered. Let's say you have one advantage party that has a trust fund of some sort. They're a trust fund baby, so to speak, and let's say they're also earning a salary somewhere. So that's a separate asset that may have been brought into the marriage as a separate money, separate asset. That can be considered by the court, and that can be used as a potential factor in awarding alimony to a disadvantaged spouse. Education is also another important factor. As I discussed earlier, if you have a disadvantaged spouse that, let's say, has a high school education, but you have an advantaged spouse with a master's degree, an MBA, or something where they're really earning a lot of money, and the disadvantaged spouse just has not yet gotten there, but they have potential. So the court will consider that education as a factor. And so the court, like I said, could order rehabilitative alimony whereby the advantaged spouse pays the disadvantaged spouse to earn their education so that they can turn themselves into a productive member of society and cover their own expenses and so on. Now, you also have to remember that these statutes, such as 36.5.121, takes into consideration whether or not a party might end up on public subsistence of some sort if they're disadvantaged and they get divorced. The courts generally will take that into consideration and try and stop that from happening if you have an advantaged party that will be able to help the other parties. In other words, the courts don't want to see you divorce and let's say you have an advantaged party that's making it just fine and has some discretionary funds at the end of the month. The court's not going to want to see the other party go out and be put on the street and left to public subsistence or something to that effect if that party, the advantaged party, has the ability to pay. The court also looks to physical condition, and this is one of the times when alimony in futuro really comes into play as well, where you have physical condition of a disadvantaged party where they can't go out and work, where they can't go out and earn the money that the other advantaged party is earning. Or age, advanced age can be a problem too, where you have someone that is at an age that they can't go back into the workforce and earn the money that they once could have because of their age. That's a very real factor because age and physical condition kind of go hand in hand as well. Once you get on up into, say 70s or 80s, we wouldn't expect for a spouse that, let's say, has been a homemaker their entire life to be required to go out, find a job, go to school or whatever, rehabilitate themselves at 75 years old, and then bring themselves up to speed in a short period of time to earn the same amount of money that, say, the other party that has the advantage and has the job and has the resume and the education might be able to move forward on. So that's something to consider as well, as age and condition, physical condition. And like I said, in futuro alimony is a long-term alimony where you would be in a situation where a disadvantaged spouse can't rehabilitate themselves. They can't go and get a college education quickly enough, and they can't do the things they need to do to support themselves, and so they're in a situation where the court might award on a long-term marriage to a disadvantaged spouse alimony in futuro, which would be until either death, remarriage, recohabitation with another party that could assist them with actually covering their bills each month and taking care of their needs and so on. So that's a consideration on a long-term alimony like that, and that's how that's generally calculated and how that's generally awarded. And then one of the things that I hear quite often is, well, I want to punish this person that I was married to or I am married to, so they're at fault in this divorce and I'm going to punish them and we're going to get alimony from them and we're going to break them. Well, fault can be a consideration. That is one of the 12 factors, but don't hold your breath on thinking you're going to walk into court and spew a list of horribles that your spouse has rained down upon you during the marriage, and that's going to just instantly get you an award of alimony. Fault is a very low on the totem pole type of a factor, I would say. Fault is something that can be considered, but I think generally we're going to find that fault is going to be one of the least considered factors at all, if at all, in the award of alimony. So keep that in mind. Alimony is not awarded to punish a spouse. Alimony is awarded to help a needy spouse to move forward with their life and to move on and to take care of themselves. So just keep in mind, alimony is probably not going to be a punishment tactic, and if that's your sole goal is to punish him or her, the person that you are divorcing, well, that's probably not going to go well for you. So you might want to speak with your attorney about that in depth before you try and move forward on that tactic. It's just not a good way to move. So with that being said, are you going to have to pay alimony at the end of your divorce if you're the advantaged spouse? Well, as I said before, that's going to be a maybe. That's a good lawyer answer, right? It's a maybe. Maybe if your spouse is disadvantaged, if they have a need for alimony, and if you have the ability, you have discretionary income at the end of the month and they don't have it, you might be on the hook to pay some alimony, and they might very well deserve it under the law. Same thing if you are the disadvantaged spouse. Am I going to be awarded alimony? Well, maybe. Another good lawyer answer, right? Maybe you may be successful in that, but you also have the burden of proving that you have the need and that the other party has the ability to pay you alimony. So I hope this has been helpful for you. Like I said earlier, I'm with the Rushton Law Firm here in Nashville, Tennessee. We handle a lot of different civil actions. We also handle construction defects, contract matters, and other types of civil litigation. So if you have a need in the Nashville or surrounding area for an attorney in a civil litigation matter, look us up on the web. TheRushtonLawFirm.com is our website. You can also give us a call or an email and contact us anytime. We'll be glad to provide you with a free consultation and try and help you out. Okay, so thanks so much for tuning in today, and if you have any questions, do not hesitate to contact us. Leave any questions you might have in the comments below, and be sure and subscribe. Thanks so much. Have a great week.